I can feel his club, yeah. I can feel his drink, yeah. I can feel a good vibe coming over me. Oh, I can feel a party, yeah. It's somebody's birthday. Happy birthday. I can feel a groove, yeah. I feel a DJ, yeah. I can feel joy. I can feel trust around me. I can feel people, and I can feel the love, and it's all in the air tonight. And it's all in the air tonight. It's all in the air tonight. It's all in the air tonight. I can feel a high, and I can feel the shots. Oh, I feel all the ladies in here looking so hot. Oh, I feel them on top. Yeah. Feels like a good day. Oh, it feels like everybody is happy, and it makes me feel great. Oh, and it's all in the air tonight. Yeah. And it's all in the air tonight. Yeah. Oh, it's all in the air tonight. It's all in the air tonight. Oh, so come on, let's stop all this hating and let's start celebrating. Life is too short for this drama, pain, and madness. Let's have drinks and party up until we see the morning. And let's make a toast to change, 'cause I feel it's coming, and it's all in the air tonight. All in the air tonight. Oh, it's all in the air tonight. I can feel it, yeah, all around. It's all in the air tonight. And I'm so glad that the spirit found. It's all in the air tonight. Can you feel it in the air? Oh yeah, it's all in the air tonight. Blessings and miracles, yeah. I'm claiming it. Oh, I'm claiming it. Yeah, I'm claiming it. Oh, you know I'm claiming it. Yeah, it's mine, y'all.
And I stayed into something. So now I'm closer to God. But being closer is hard. The attacks get stronger, become much harder to fight, and they last longer. That's what it's always been. Joy with the pain, dark with the light, sun with the rain. With the right perspective, there can be something to gain.
Yo, can I with you? What?
ACT, did you see this?
Look, if it ain't official DanaJay, Levi for Kelly, or Prima Donna News, I don't even want to see it. Just take it off. Look, you got some weed? Dang, I gotta get some. All right, hurry up. Diesel and them here, everybody here, we waiting on you. All right.
But I know that there's more. More for you, more for us.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
Say you love it, what you gonna do Yo! Alright. We about to get this motion out the way real quick. Let's see what the government had to say. You feel me? Let's see what the government had to say. I am interested in what the government had to say. I am interested to see what the government have to say. I'm claiming it. I'm claiming it. I'm claiming it. Oh, in the air tonight. No, the is mine. Let's see what's going on. Connection there. Let's see. Good. That's not the one though. Let's go ahead. All right. Let's see. Okay. Hold on. We gonna talk about it. We gonna talk about it, man. Okay. It's not showing my pods. Let's see. That's all it shows. Get pods. Got pods. All right. I got pods. Okay. We about to get into it. Here we come. Okay. About to get into it. I think it's had the wrong one. All right. United States versus Roberts versus Kelly, criminal docket number 19-2-286. Dear Judge Donnelly, the government respectfully submits this letter in opposition to the defendant's April the 5th, 2022 motion for reconsideration of the court's order denying in part the defendant's motion to adjourn his sentencing. See ECF number 285. Specifically, the court denied the defendant's motion to adjourn his sentencing to a date after his trial in the Northern District of Illinois, NDIL, pursuant to the court's April the 5th, 2022 electronic order. The defendant is currently scheduled to be sentenced on June the 16th, 2022 at 10:30 a.m., more than 8.5 months after the jury found the defendant guilty on all counts. Reconsideration of the court's decision is not warranted. First proceeding with the defendant's sentencing prior to his NDIL trial does not violate the defendant's Fifth Amendment rights. The Fifth Amendment provides in relevant part that no person shall be compelled to in any criminal case to be a witness against himself. As the Supreme Court has long held, this prohibition not only permits a person to refuse to testify against himself at a criminal trial in which he is a defendant, but also privileges him not to answer official questions put to him in any other court proceeding, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceedings. Minnesota versus Murphy. That's a case law. Eternal quotation marks omitted. The potential statements at issue here involve the defendant's provision of information to a private mitigation expert hired by his defense counsel. Whatever information the private mitigation specialist will potentially provide to the court would not be based on any compelled statements of the defendant. Indeed, the defendant is not being compelled to say anything. He is potentially choosing to do so. That is, of course, his choice. But while the Fifth Amendment shields a defendant from the consequences of his compelled statements, it is not a sword that allows the defendant to benefit from a voluntary choice to make statements without any conceivable risk. Indeed, this choice is faced by all convicted defendants when they decide whether and to what extent to provide information to a probation officer preparing their pre-sentence investigation report regarding the offenses of conviction, particularly those like the defendant convicted after trial who intend to file an appeal, as the court in United States versus Davis observed in denying a defendant request that he be permitted to make statements to the probation department and to the court in connection with sentencing without having much such statements used except in the sentence proceedings in order to preserve his right to a meaningful appeal. The defendant exercised his Fifth Amendment right at the trial and declined to testify. He is still entitled to the Fifth Amendment privilege at the time of sentencing and can decline to make any statement. On the other hand, the defendant is entitled to speak on his own behalf in connection with the sentencing. He is entitled to address any comments to the probation department and to the court, which he believes will assist him. If the defendant chooses to speak, and if he should make admissions of guilt or should make false statements, certain consequences may follow. There is no basis for the court to insult him from such consequences. This is a case law, United States versus Slayton, Southern District of New York. Thus, the defendant's reliance on R.I. versus Ennis, 446, United States 291-301, which is case law, at one is entirely an apposite. There, the Supreme Court held that Miranda safeguards come into play whenever a person in custody is subjected to either express questioning or its functional equivalent, and explained that interrogation under Miranda refers not only to express questioning, but also to any words or actions on the part of police. Wow. Other than those normally intended to arrest and custody, that the police should know where reasonably likely to elicit an incriminating response. Ennis 446 U.S. at 301. Emphasis added. And noting that by incriminating response, we refer to any response, whether inculpatory or exculpatory, that the prosecution may seek to introduce at trial. ID at 301 N5. The Supreme Court was clearly referring to custodial questioning by police. Here, the questioning at issue is neither custodial or conducted by law enforcement. It is voluntarily questioning by a defense-paid mitigation specialist, which the defendant can decide to use at sentencing or not, and raises none of the Fifth Amendment issues to the Miranda rule was designed to address. Sentencing. We do not find that such a constraint raises to the level of compulsion required by the Fifth Amendment. Emphasis in original. United States versus De La Paz. Affirming district court's refusal to grant a continuance of sentencing where defendant following his guilty plea to firearms offenses. What? Requested a continuance because he could not adequately exercise his right for allocution because an indictment for an continuing criminal enterprise was pending against him, and the information he wished to mitigate his sentence for the firearms violating might be used against him in the pending trial. That's the wrong case law to use. Why would you use a case law concerning firearms? Okay. Notably, the defendant's expressed concern here is even further removed. Statements made to a mitigation specialist retained by the defense are inherently less risky in this regard than statements made to a probation officer, during a pre-sentence interview, or to the court at the sentencing proceeding. Defense counsel will undoubtedly have the opportunity to discuss any statements made by the defendant to the mitigation specialist with the specialist prior to any disclosure to the court, and will be able to review any report prepared by the specialist prior to making a decision to submit any or all of the report to the court. Moreover, as noted in the government's response to the defendant's original motion to adjourn sentencing, the same alleged concern about future use of potentially incriminating statements made to the mitigation specialist exists even when only considering the defendant's case in this district as such information. What? Could affect that defendant's appeal and any new trial sought by the defendant on appeal. See ECF number 281. Okay. Again, given that the same purported concern would exist even after the NDIL trial, the existence of the NDIL trial cannot serve as a valid basis to delay the defendant's sentencing. Wait a minute. But y'all delayed it for 5 months. So when he wanted to delay it just to make sure he's straight, now there's a problem. This is weird. Notwithstanding that the defendant's concern does not provide a valid basis to delay his sentencing. Wait a minute. Notwithstanding that the defendant's concern does not provide a valid basis to delay in his sentencing. So if y'all agreeing that it provide a valid basis, then what's the problem? The government nonetheless proposed a procedure that would address and alleviate those concerns, namely allowing the defendant to file any mitigation report or relevant portions of it under seal, and issuing an order prohibiting the government from disclosing the report to anyone involved in the NDIL prosecution. Y'all cannot be trusted. The defendant simply asserts without any discussion that the proposal does not sufficiently protect defendant's Fifth Amendment rights. It don't. As discussed above, however, proceeding with the defendant's sentencing does not violate the defendant's Fifth Amendment rights, and the defendant bald assertion to the contrary is not a sufficient basis to delay his sentencing. Why ain't it? Particularly where, as here, there is a way to ensure that any potentially incriminating mitigation statements made by the defendant that he wishes the two defense counsel also presumably will have the ability to request that changes be made to the report prior to deciding whether to submit it. And 3, indeed, the fact that the defendant's concerns necessarily exist both before and after the NDIL trial is what renders the defendant's justification for a sentencing delay disingenuous. Okay. Court to consider at sentencing can be provided to the court without risk that such statements will be used by the prosecution in NDIL. Finally, the defendant's acts is not a small one. At 2, whether the defendant likes it or not, his accusers are victims of serious crimes and have rights under the law. Those victims have the right to be reasonably heard at any public proceeding in the district court involving sentencing, and the right to proceedings free from unreasonable delay, 18 U.S.C. 3771 A4 and A7. Furthermore, where the court to grant the defendant's request, the government anticipates that the defendant will make additional requests to delay the defendant's sentencing on precisely the same legal baseless ground, given that the defendant also faces criminal charges in state court in Illinois and Minnesota. Moreover, the court cannot predict whether an unforeseen development in the NDIL case will delay the trial there for an unknown period of time. Stop. Let's back something up. The biggest lie that was told was the Minnesota case was dropped, right? So let's read that again. Furthermore, where the court to grant the defendant's request, the government anticipates that the defendant will make additional requests to delay the defendant's sentencing on precisely the same legally baseless ground. So how can it be legally and baseless? Make it make sense. Given that the defendant also faces criminal charges in state court in Illinois and Minnesota. Like I told y'all before, the Minnesota case was not dropped. So everybody that ran with that lie, here it is in the motion. The defendant also faces criminal charges in state court in Illinois and Minnesota. Moreover, the court cannot predict whether an unforeseen development in the NDIL case will delay the trial there for an unknown period of time, requiring the defendant's sentencing to occur after the NDIL trial and any other as yet unscheduled trials in the defendant's pending state cases to address the defendant's purported Fifth Amendment concern is simply not reasonable in these circumstances. The government, Jesus Christ, this is the worst. The government wrote a bunch of nothing. Only thing they saying is, we don't think that he should be extended. They ain't saying nothing. However, when Abongine brought the meat and the potatoes, the government only bringing side orders. So for all the people that got out there that cashed that, Sylvia, and that other lady, Miss Lady D, and was celebrating, and I told y'all that his case in Minnesota is not gone. The only thing they did was put it on a back burner, but they did give him a body attachment for the $2 million. After reading that, the government don't have nothing. Ms. Bonjean asked for specific stuff. They citing wrong case law. Why would you cite a case law about a man with a handgun? Of course, that's going to outweigh something, because he got a handgun. And at that time, and you need a license. So therefore, that charge is going to outweigh anything Robert has. Robert don't have nothing with a handgun. He got alleged crimes. Alleged crimes. From scorned people who couldn't get their way with Robert anymore. And it's more than just Azriel. If you was at trial, you'll see Canick destroyed their stories, poke holes and pulled it apart and everything. It's not making sense. It's not making sense. So y'all collecting money, talking about Robert case was dropped. Yeah. And then the federal government come back and smack you with that ooh-wee and telling you the case still open. But when Dana told y'all the case was open, oh, he don't know what he talking about. He not talking to nobody. And here you go, right here. The government come back and tell you exactly what I said. He got served with a body attachment for a debt collection of funds. But if anybody was smart, they would ask the government a question. Well, the Minnesota people. How do you pay a debt with that? So I'm expecting Bonjean to come back and rip this 4-page of nothing apart. I'm just trying to figure out, like Azriel was able to go see him for 6 months, right? But if she was y'all star witness, how was she able to go see an inmate? Nobody have yet explained that. I've heard somebody try to explain and say, well, at that time, she wasn't working with the government, and she was all pro R. Kelly and this and this. And then when he wouldn't take Joy off and keep her on, and you know what I'm saying, that's when she turned. It's not making sense. El Chapo wife couldn't go visit him. When they came and locked him up, she couldn't go see him. So how was Azriel able to go see him? This water tastes stale. There's something in this water that stinks. I'm just saying, Dream Team. Vi said she was always working with the government. I don't believe she was by herself. I think it was some other hands in the water too. So let's keep doing what we do. Let's keep robbing first. I know some people want to have a rally in New York. Are y'all ready to be confronted with those accusers? Can y'all keep y'all composure and not act a fool on camera and look stupid? Like other people has done on cameras when they tried to get interviews? I'm just saying. Hold on. All right, look. I got a message. So I'm going to end this, then I'm going to come back live. And I'm going to title it, Shaquetta Got a Message for Daboski. Like I say, it's a dirty game. So I'll be back in 1 second. Let's go ahead and end this jump like this real quick.
Swimming in you. Hey, little mama said I wanna take her. Dipping your pool. Just go pollute out there. Hey, yeah, yeah, yeah.